ICC's epic ruling may have been delivered barely 24 hours ago, but the government seems to have been jolted into action, triggering a sequence of events that bring to life possibilities that appeared elusive for the past 4 years.
I have, with immediate effect, directed the Attorney General to constitute a legal team to study the ruling and advise on the way forward.
The team is already in place, one called a multi-agency task force. It's a 10-man panel made up of Sir Geoffrey Nice, a Queen's Counsel, Rodney Dixon, an English barrister, senior counsels Fred Ojiambo, Waweru Gatonye and Joe Okwach, international law experts Godfrey Mosila, Betty Murungi, Lucy Kamboni and Grace Wakio, and Moi University lecturer Dr. Henry Mutai.
It is the hope of the Kenya government that this team will be able, in a professional, independent, impartial manner, to advise the government on how best we can move forward, conscious always of the rights of the accused person, and even more critical for the Kenya government, the rights of the victims.
And while that process takes off, the Attorney General has yet another assignment to accomplish.
I will be approaching the Honorable the Chief Justice, Dr. William Mutunga, Chairman of the Judicial Service Commission, with a view to summoning an urgent meeting of the Judicial Service Commission of Kenya to discuss the possibility, the viability of setting up a division of the High Court to deal exclusively with offenses of an international criminal character.
With 4 Kenyans now facing crimes against humanity charges at the ICC, can the government still seek a referral of the cases back home?
The Rome Statute recognizes that possibility.
As things stand, there is no room to return the cases back to Kenya.
As to whether the Kenyan case at this point in time is a suitable case to be transferred from The Hague to Kenya is something that this legal team of very eminent persons will advise, among other questions.
Let's underscore the fact that the cases, now the 4 cases against the 4 accused individuals are at the ICC because of the failure of government, the failure of parliament, the failure of our institutions to take their responsibility when they should have.
The ICC only intervenes if a state is unable or unwilling to investigate and prosecute crimes against humanity committed within its jurisdiction.
In our case, it was unwillingness, total inaction. The victim's plight remained unaddressed. There was no accountability for perpetrators, and that is why the ICC intervened.
Vice President Kalonzo Musyoka's shuttle diplomacy to mobilize African Union members to support Kenya's push to have the cases tried locally failed last year. However, the government says a lot has changed since. A new constitution is now in place, and a serious reform agenda is being implemented.
Today, we have pending with the Commissioner of Police, the Director of CID, and my learned colleague, the DPP, 5,000 files. We've been consulting on the best way to bring these cases to closure.
5,000 pending files and cases over 5 years does not begin to scratch the surface.
According to the acting head of Kenya's International Center for Transitional Justice, the government lost its admissibility challenge at the ICC because it failed to demonstrate that there were ongoing or concluded investigations or proceedings against the Ocampo 6. That fact hasn't changed to date, she says. However, according to Alai, even though the state failed, the accused can still file an admissibility challenge.
But for a limited period of time, they can challenge admissibility of the cases before the ICC only until before the commencement of the trial.
The admissibility challenge in this case will seek to demonstrate that the ICC has no jurisdiction over the Kenyan cases because the state was not unwilling to prosecute or investigate the crimes against humanity that are before the ICC. Sylvia Chebet, Citizen Live at 9.